John, there's a new opening on the Supreme Court, which we could talk about, but it's got nothing to do with healthcare.
Oh, what about the Affordable Care Act? What about abortion rights? What about gun rights? I think you're missing something.
Well, sounds like you've already started the oral arguments. Welcome to CareTalk, your supreme home for incisive debate about healthcare business and policy. I'm David Williams, president of Health Business Group.
And I'm John Driscoll, the CEO of CareCentrix.
Well, John, it's acronym time again, one we don't get to use that much. SCOTUS. It's a SCOTUS talk. It sounds like a weird part of the body somehow, but I think we'll have some fun with it.
I think the Supreme Court could not be more important and could not be less focused on until this nomination. So I think it's a great topic.
All right, John, let's go for it. So listen, John, I mean, Supreme Court in healthcare, everybody talks about it, but just broadly, I mean, what role does the Supreme Court play in healthcare anyway?
Well, it really probably shouldn't play any role at all. I mean, the reality, if you look over the history of the United States, we've actually spent most of the time with the legislature legislating, the president signing bills or not signing bills. And particularly with regard to healthcare, we've sort of drifted into the Supreme Court at being the arbiter of decisions, whether it's Brown versus the Board of Education around segregation, or about the Loving case around, interracial marriage, or the most recent healthcare example is upholding the ACA. So we've gone from a country that was focused on making laws and passing laws with the legislature to one that passes laws and then fights over it and lets the decision be made by people with permanent long-term appointments who dress funny.
Yeah, no, that's fair enough, John. I mean, we dress funny, so maybe we could get on the Supreme Court on that basis. I think we're both way too old. I think you have to be about 21 now to be appointed. So
I'm very comfortable with the outfit, having grown up a Catholic, David. I think, but seriously, why do we let these judges make decisions that our electoral system is supposed to make on its own? I think it's kind of crazy, but there's no question. I mean, they are pretty central right now to whether the ACA, whether healthcare for all Americans, or for at least a few Americans, is going to be upheld.
No, that's absolutely right. I mean, I think, they're the final arbiter of the law. So I think, let's take a look at some of the things that have happened recently. So everyone knows about the Affordable Care Act, but we'll come and talk about that in a little bit more detail. But, some things that you consider in healthcare, like reproductive health. So there's recently, some states have tried to make it so that they try to limit or restrict abortion completely. And they said, well, a physician who is performing abortions has to have hospital privileges nearby. So the court ruled that, no, you can't do that. That's an undue burden. But on the other hand, they also said that, employers don't have to cover things that they don't agree with. So that means an employer doesn't have to pay for contraceptive coverage if they object to it on religious or conscience grounds. I mean, those are a couple of things outside of the ACA.
Yeah, I think the fact that the Supreme Court is making these decisions is kind of ludicrous. I think that it is a great example of that the extreme partisanship and the inability, the vast, 70% of America agrees that that women should have access to abortion in general. Many folks will want to restrict that last trimester access. The vast majority of Americans agree that contraception should be broadly available, and yet we are permitting the Supreme Court to kind of drift into this decision maker role, which I don't at all think was the original intent of the framers. It's interesting and I don't think it's a liberal or a conservative thing, but the role of the court in making decisions, I think, has gotten a little ludicrous.
Yeah, no, I think it's up there, John. I mean, in the general grounds, I was reading an article that was saying that, if the new nominee is appointed, then the majority of the justices will have been appointed by presidents who did not receive a majority of the popular vote, which is certainly Trump with 3 and Bush with 2. So, it's kind of nuts that that's who is the ultimate arbiter, and they are really not representative. So let's talk about Affordable Care Act, such it is, or since we're using the broader acronyms, I think originally it's really PPACA, Patient Protection Affordable Care Act. So There are a couple times that the Affordable Care Act has come before the court, and it's kind of survived pretty well. I mean, the weird thing was in 2012, a couple of years after the law came into play, the whole thing was challenged. They challenged it kind of on the individual mandate, and the individual mandate and the law in general were upheld, but they surprised people by saying, well, Medicaid expansion, you can't force the states to do that. And that was a surprise and very ideological that the states, many of them, then didn't follow through and accept the Medicaid expansion, even though the feds were paying for almost the whole darn thing.
Well, I think again, this is let's step back and say, do we really want a group of unelected permanent appointees to be making these decisions that should be litigated, negotiated, deliberated on, and decided on our elected representatives? It's sort of crazy. But now that is the system we've got. Look, November 10th, 7 days after the election, the ACA is up, and we've got a president who's trying to shotgun and fast track an appointment, even though he didn't get the popular vote and may not even be the president after she is potentially nominated and confirmed. And so we've got a system where these critical decisions around healthcare policy, access to care, access to services, are potentially going to be tilted in the wrong way, simply because we've sort of lost track of what should be the decisions on the legislative side of the elected representatives, and what should be a truly constitutional question regarding this that would be appropriate for the Court of the Supremes. I mean, I think it's a dangerous structure that has drifted, and now it's being manipulated. I mean, I don't see how the president can justify slamming this approval through, this nomination through, when so much is at risk, and it should be decided by the legislative side, by the elections. I mean, how do you feel about that?
Well, I think, sure, John. I mean, I was still quite angry that President Obama's nominee, Merrick Garland, wasn't taken up at all by the Senate. And it was 10 months before the election. And now, the same Senate Majority Leader McConnell all of a sudden decided, principles be damned. It doesn't really care whether it's hypocritical or not. Just want to ram somebody through. I mean, it's ugly. So so the first thing is listeners, make sure that you're registered to vote and that you go and vote in person if possible, so that your vote will definitely be counted. But in the meantime, let's say, what is this case going to be about the Affordable Care Act? I mean, really at stake is the whole law, right? Because the whole law could be struck down if the Supreme Court upholds the lower court decision on that. So what would happen, John?
The first thing we're going to lose is pre-existing conditions. The one thing that the 99% of Americans agree on is that, and the number of people with pre-existing conditions has just gone up by 7 million of those people who've gotten COVID. So you've got the hundreds of millions of people with pre-existing conditions, which is a broad category for anybody who's suffered from any form of chronic illness or incident that would suggest a condition that could make them sicker later. And that is one of the most universally beloved aspects of this law, will be lost.
No, but John, we don't have to worry about it because Mr. Trumpy, your president, signed an executive order that says pre-existing conditions will be protected.
Again, as we think about appropriate roles of accountability, he has no authority.
Well, John, maybe he's going to tell TikTok they have to pay for all the pre-existing conditions. How's that?
We will lose protections against pre-existing conditions, and millions of people will lose their health care in the middle of a public health crisis, which is where we've got a virus that's running through our population and making people sick. And we already have, 1 out of 4 Americans worries about being able to afford the health care when they've got coverage. I mean, it's a tipping point into, I think, the chaos of politics will now turn into chaos in healthcare, and you could call him that he is definitely the chaos candidate. But when you start taking people's healthcare away, I think it's extraordinary. Last night in the debate, he was challenged on the fact that that he had a beautiful plan, and that it's been 3.5 years in, and there is no plan in it, and what we see is far from beautiful.
So, John, let's talk a little bit about the pre-existing conditions some more, because I don't think we can expect the general public or even our healthcare wonky listeners to understand all of the Affordable Care Act. But these things are all intertwined, and with pre-existing condition, it's not enough to say you'll cover pre-existing conditions, right? You also have to. There's also other parts of the Affordable Care Act that are in effect here. So, for example, annual caps and lifetime caps. If you cover pre-existing conditions, but you say, well, we don't cover you after $50,000 for the year or $500,000 for your lifetime, that's not that useful when we have when we have costs that are so expensive. If you can actually raise somebody's premium because they have a pre-existing condition, then that doesn't work either. And the individual mandate comes in here as well, because the same way you don't have the same kind of pre-existing conditions coverage in other industries. Like if your car is already crashed, you can't buy insurance. If your house is on fire, you can't buy insurance. You can't buy life insurance. If you're about to die. So we do it differently here in healthcare. And the way it could work is if everyone has coverage. If you just wait until you're sick to get coverage, it doesn't work. So there is a combination of needing everyone to be in coverage in order for pre-existing conditions to work, and then all the other things that surround it to make it happen.
CMS itself admits that 50 to 129 million Americans, 20 to 50% of Americans have some form of a pre-existing condition. It so biases the pool that unless there's a clear rule there, you will see these weird things like, hey, you're insured until it gets too expensive. Hey, you're insured, but because you had a pre-existing condition 20 years ago, it's going to cost you a lot of money. Hey, you're insured, but you're not insured because you can't afford the coverage, and there's no way to get you the coverage. I mean, it is a critical component in making the system work. Take that away, the system becomes really unhinged. And all of the reasons that people hate insurance, surprise bills, surprise requirements, limits on coverage, all will come back. It could really be a horror story for healthcare for tens of millions of Americans.
Now, John, there's a new nominee out there. And so Ruth Bader Ginsburg, may she rest in peace, has left the scene. And a new person is there. Now, to me, she seems very good because she's also a woman with three names, Amy Coney Barrett, so like Ruth Bader Ginsburg, and she's a judge. And so, boom, you just replace one or the other, be a seamless transition. What do you think?
I think it's insane. I mean, even, Abe Lincoln in the middle of the Civil War did not want to replace a Supreme Court justice during an election, this close to an election. And we're even closer now. Amy Coney Barrett is clearly a highly qualified judge, but she is disqualified as a candidate to shotgun this through during the middle of an election. Each party has the right and and probably the obligation to promote ideologues of their own. Historically, both parties have moved towards the middle in their nominees, with some rare exceptions. The nomination and votes on Supreme Court justices until the last 20 years were actually disorientingly bipartisan. And that has not been the case recently. But no one has tried to shotgun a new Supreme Court nominee in this kind of timing, in this kind of an election, particularly at this volatile time. I think it's going to add fuel to the fire of the current partisanship, potentially make the court more unstable. And that is with a qualified candidate, because she and just to be clear, although she's qualified from a legal perspective, she's pretty extreme. She's attacked the ACA pretty directly. She's undermined and questioned the rationale for access to abortion rights at Roe v. Wade, and she is also rather an extremist on the Second Amendment. Firmly standing on the position that nonviolent felons should have access to weapons. I mean, she is tailor-made to create more contention on the court, as opposed to actually bring the court together. And I think that's, whether it's bringing the court together or the legislature, it's just crazy. It's crazy making, David.
John Roberts, Chief Justice, has actually, I think, seen the importance of keeping the court as non-political as possible, and he's come over to be more of a centrist over time, because I think he sees the importance of, preserving the court. I think that there's a chance that the court is not going to be, and the courts in general are not going to play such a central role in the future. What the Republicans are trying to do now is to, lock in tons of very conservative judges for the next generation. So even if they lose the elections, that it won't matter so much. But I think there's a real challenge if we're going to preserve our democracy. We can't have minority rule. It has to be ruled by the majority. And I could actually see that we may see a reduction in the power of the courts in the coming decade.
Well, I think you're going to see a huge movement if she's forced through, which it looks like everything's going to happen that way. You're going to see the Democrats move very, very quickly to try to pack the court or to limit the lifetime appointments. There actually is some history, David, of passing law and excluding it from the jurisdiction of the Supreme Court. It's been done rarely, and courts don't like it, but that could happen. You could also see some sort of attempt to go to the middle, where for a certain category of decisions, it would not be just a simple majority, but it would have to be greater than either a unanimous decision or 7-2. But I think the Republicans will rue the consequences of politicizing and destabilizing the process in the court. And what will happen is there will be a natural counterreaction, either narrowing the court's mandates, because I don't think anybody really wants the courts making decisions on these critical social issues in the context of litigation. It just, when you step back from it, it doesn't, why would people who have no policy, no accountability, no economics, and not even necessarily the categorical backgrounds that you'd need to make decisions on the complexities of healthcare, kind of picking these bills or throwing them out? And I think it's infuriating, and it's going to be even more infuriating if the Supreme Court just becomes a partisan tool.
No, John, I'm with you. In some other countries, people are looking at it and saying, gee, this points out about how we do it better, elsewhere. It's not as politicized elsewhere. You do have some of these things you're talking about, like term limits and not having the final word on everything there. So I think we'll see that. And I agree with you, John, about healthcare. I also agree, John, this has been a supremely interesting discussion. When we said we were going to talk about your SCOTUS, I was a little concerned, but I'm glad that it's come out a little bit better.
Our SCOTUS is in trouble.
Yeah, no kidding. All right, John. So, well, this is it for another edition of CareTalk. I'm David Williams, president of Health Business Group.
And I'm John Driscoll, the CEO of CareCentrix. Thanks for listening.